heading back to the station now, so I'm asking Alan to give a historical perspective, legal perspective on the Brexit debate, our position. We tried to broach the subject yesterday about Schuman and what he might have thought of where we are today with the European Union, particularly Britain's place in it. And I had an interesting conversation with Alan yesterday about this, and I just thought we ought to try and capture it in a slightly haphazard manner on the way back to the train station, rumbling down our lane, which is probably producing quite a bit of noise. But Alan, can we go right back and talk about how British law sat or sits with EU law, and why Britain in particular is a bad fit, why we are an exceptional case in a sense? Does that make a good question?
Well, when St. Ethelbert of Kent, the first Christian Anglo-Saxon king, was baptised, St. Bede tells us that he began to make laws after the Roman fashion. And he doesn't explain, it's a tantalising comment, doesn't explain it. But we know that the Roman legal system was codified in the 530s by the Emperor Justinian, which fundamentally changed its character so that it became the product of a single imperial will, instead of being accumulated over many centuries from a great number of different sources of law, edicts of magistrates, decrees of the Senate, plebiscites of the people, the original 12 tables, and all sorts of different ways, including laws created by emperors. And those had been codified by the Christian emperors, but only the laws made by the emperors had been codified. The fundamental basis of the legal system remained a more multivalent republican structure. And whereas in Justinian codified everything into a single code promulgated by him, and so there was something much more totalitarian, perhaps that's unfair, but certainly much more statist about the structure of the law in the surviving Roman Empire in the East. But that never really, it had no impact in the West, because Justinian's reconquest of the West didn't take. So when it says that he began to make laws after the Roman model, it can only mean in the Roman fashion, not the actual content of the Roman laws. And if we think about what did people know in the West about Roman law and what it was like in the Dark Ages, really the great resource was this book, which might be described as the Hitchhiker's Guide to the Dark Ages, called The Etymologies, written by St. Isidore of Seville. And it's a kind of mini encyclopedia intended to transmit knowledge on many different areas in society, in which books, are worth more than a village and take a very long time to produce. And it has a section on law, but it's based on Gaius's Institutes, written in the 2nd century, which is much more conservative, more republican, earlier vision of Roman law than that's expressed by Justinian. And particularly in Justinian's Institutes, which is a kind of guide to legal theory that goes with his code, he invents this principle to justify the emperor issuing laws on his own authority, called the lex regia. And the principle is the pleasure of the emperor has the vigour and the effect of law, since the Roman people by the royal law have bestowed upon them the full extent of their own power and sovereignty. And this, although it's actually a principle invented to justify a particular invention, novelty in the Roman legal system, it ends up being very influential, and it stands behind the kind of statist conception of the law and its place in society that you see in contractual theories such as those of Thomas Hobbes. And there's a whole tradition stemming from this lex regia, which is different from the original Roman legal tradition, in which the authority of the law came from the fact that man is a social and political animal, and naturally lives in an ordered society that needs rules.
I remember something from that era, and it came out of Navarre, somewhere in the Spanish area, and they said, "We elect you to be our king. You who are no better than us."
Yes.
It was something really very.
Yes.
It's just that we need somebody to lead us. So look, it's going to be you, but just you remember.
That's the oath of Aragon. That's
Right.
Yes. And it says, and it lists the liberties which he must respect, and then it says, and if not. That's the last line of the.
Not.
Yes. Yes. I would say the English legal system, based on precedent, more closely resembles the theory of the earlier original Roman legal system, if not the content. So the content is essentially natural law informed by Christian revelation in a structure corresponding to the theory of Roman law from an earlier period than that of Justinian. But then in the 11th century, Justinian's codification was rediscovered in the West, and it was medieval lawyers were terribly impressed, and of course it was very useful, and it was, in a way, one of the reasons the codification occurred is that, rather like the English legal system now, the Roman legal system before the codification required a huge academic apparatus and libraries of books, and that just didn't correspond to the realities of the Roman Empire as it was struggling to redesign itself in order to survive in Justinian's time. So codification made a lot of sense. As it were, what Justinian was attempting was a sort of Encyclopedia Britannica version of Isidore's Hitchhiker's Guide to the Dark Ages. So the continental jurists concentrated in Bologna were delighted with the rediscovery of Justinian's code, and it's swept across the continent, and but it came to a halt at the Channel because the English legal system, the common law system, had developed sufficiently, and the English lawyers were sufficiently proud of it that they wouldn't accept it being supplanted by the Roman law. So for the rest of the Middle Ages, the English common law system was a peculiarity of England as against continental Europe. But then, as a result of the vast colonial possessions of Britain, climaxing with Britain ruling a quarter of the population of the world and a quarter of its surface, that ended up becoming the legal system of half the world.
Yes.
And so you end up with these two great parallel systems, the civilian system as it's called, and the common law system. And there are two ways I've heard it epitomised, which I think are quite suggestive. One is sometimes they say that in England we have liberties, whereas on the continent they have rights. And what that's supposed to mean is that in England, society pre-exists the state, and the state is a structure for the benefit of society.
Yes.
And you can do anything so long as there isn't a positive law promulgated to prohibit you from doing it.
So just to clarify, the state exists for the benefit of society,
which is something,
and its only value is in to promulgate those freedoms. So it has no value if it doesn't serve that freedom.
Law is derived from morality, in the sense that morality is a description of how to be a flourishing, happy human being.
Yes.
And the part of the English legal system which just corresponds to natural reason and natural justice is the common law precedent-based part. And then when you get to those things which Roman law calls jus civile, the things which are specific to a particular jurisdiction, like which side of the road you drive on, or how many pennies there are in the pound, those things are determined by statute. But anything else, you can just do what you like, and these are the liberties of an Englishman. Whereas on the continent, the state is primary and the individual is secondary, and you have rights, which is a list of things that the state allows you to do, and for everything else you have to ask permission. So the order of things is completely inverted.
Yeah.
And another way in which I've heard it. A friend of mine pointed this out to me the other day. In continental Europe and in general in civilian countries, everybody is obliged to possess an identity card.
Yes.
A state-issued identity card, and they are obliged to register where they are. If they stay more than a few days in any place, they have to tell the local authority, the mayor's office or whatever, that they're there. And it's a criminal offence for them to go more than a certain distance from their registered abode without possessing their ID card. And if a state official, a policeman or whatever, asks them to produce the ID card and they're more than that distance from their registered address, they're obliged under legal penalties to produce that ID card. Whereas in England, if a policeman comes up to you and so much as asks your name without reasonable grounds for suspecting you're committing a criminal offence, the policeman commits a criminal offence.
So when we came to join in the 70s, these two diametrically opposed view of sort of the human persons and the freedoms, and the diametrically opposed view of what the state is in relation to the individual. How was that brought together in European law?
The European legal system is very cleverly constructed so that some laws which are passed by the EU are what used to be called directives. They tell the member states to take the content of this directive and translate it into its own legal system. And some of them are what's called regulation, or used to be called regulations. The language has shifted a bit over the years, and they directly become law in all of the different member states. And the way in which now, in continental systems where they have codified law, they're just added to the code, and nothing fundamental has changed. But in England, where we have common law, they've used what's called statutory instruments largely to implement these European laws. Statutory instruments are secondary laws, which are some primary laws. A statute enacted in Parliament empowers ministers to create these secondary laws, and so long as the Parliament is given notice of them on a notice board somewhere in a basement somewhere, as long as a certain number of MPs don't object by a certain date, they just go automatically into force. And what this has done is it's slowly assimilating the English legal system to a more continental model. And of course there's a lot of dispute over what what the volume is, but even quite impartial observers have conceded it may be up to 50% of all law as things stood at the time of the referendum was being made in Europe and not in Britain. Lord Denning, famous judge, once famously described it as an incoming tide that couldn't be resisted, that was slowly transforming the English legal system. But I mean that's so. But I'm not trying to be jingoistic about this. These are only peculiarities of England because of the sudden entry into the Western Latin legal tradition of the Byzantine codified law in the 11th century. So really, it's just that great gulf between a Latin conception of the role of the state and a sort of Hellenistic conception, which used to divide the West and the Adriatic. That gulf was repositioned to the English Channel as a result of that discovery in the 11th century.
So your position was we did irreparable damage, or have done irreparable damage to the English legal system?
Well, not necessarily. I think after the departure from the EU, depending on how it's managed, the inherent structure of English law ought to reassert itself, and the creeping codification slowly be eroded.
It's just interesting having this conversation now because of the drafting of a paper where the government, the Conservative government of all governments, not Tony Blair's government, who tried it 8 years ago, but the Conservative government hoping to legislate to change the law in favour of the state granting 12-month licence for homeschool families, of which we are one, which is a sea change in the law, whereas in the current British law, the family is the provider or the insurer of the child's education as a fundamental right. So even if we sent our child to another school, it would be still our responsibility to provide that child's education, whether we subcontract that. But now it's going to become the states without any, well, I mean, there is a public consultation, but it is an extraordinary change in the conception of what an individual or a family is.
Yes, it's very dangerous erosion of the English conception of law and the role of the state, because the fact that the parents are the educators of the children and they may delegate that to the school if they so choose is fundamental to this idea that society precedes the state. And to say that the state is fundamentally the educator, which permits in exceptional cases the parents to educate their children, is both false, absolutely speaking, and a serious breach in the English tradition of liberty.
So there's just one. I mean, I call it a small example. It doesn't feel small to me, and that I suppose is happening elsewhere. Okay, so we've dealt with the law side. Is there anything else that we could discuss? We've got 10 minutes before.
I think the interesting thing, reflecting on Schumann's concerns about how the European project could, in theory, go wrong.
Yes, that's good. Yes, let's talk about that.
Is that which relates to these questions we've been discussing? Is that for Schumann, the nature forms peoples into nation states, for want of a better word, individual polities, which overlap organically, like in the United Kingdom, the England, Ireland, Scotland, and Wales, or the Austrian monarchy, made up of lots of different. But that's a natural organic growth. The existence of a universal supranational society is a consequence of supernatural realities, and that's why Maritain thought that the mere existence of a European Federation would be sort of implicit to Christendom. But if you take away that, if you take away that Christian inspiration, and this is not something which Maritain considered, but it is something Schumann considered. If you take away that Christian inspiration, the structures which you've created, no longer having a supernatural justification, will try to go natural as it is, as it were, turn themselves into a super state, turn their constituent nations into provinces of one large sovereign entity. And I mean, I think that very much is what has happened. And the problem is that whereas because the various national states are natural entities, they have their own political culture in which everybody knows. They know their politicians. They understand their facial expressions and their personal quirks, and they can read between the lines, and so they're able to hold their political culture and their elites to account, and elections are a meaningful thing. But that's not true, because there's no natural common political culture in a supranational structure of that nature. There's no, even though the European Union has elections for the European Parliament, and which has a certain degree of control over the Commission, although it's rather limited. Nobody knows who those members of the European Parliament are. They certainly don't know who the members of the European Parliament are in other countries. So there's the idea that somebody from a completely distant part of the country could be a figure who's familiar to ordinary people, as is the case in Britain. famous backbenchers, Frank Fields, Jacob Rees-Mogg, JUNCKER, people know who they are. But that's not going to be the case over many different languages, many different cultures, and so what you end up with is something worse than an overmighty national state. You have an overmighty super state, which doesn't, in which the people aren't even able, the basic structures of language and culture aren't even there in order to hold those elites to account.
Yes. Yes.
Somebody said once it's a little bit like contracting your legislative functions to FIFA.
So how's your own journey towards, because you've obviously were studying for quite a long time for the doctorate. Did your position change over those years?
Yeah, I mean, my family, my grandmother is French. I have lots of relatives in France and Belgium, and I've always been, since I was a child, very enthusiastic about European integration. And studying Schumann caused me to realise that there is something potentially Babylonian in those kind of structures that can go very badly wrong. And the more I looked into Schumann's thought, and the more I taught in Aberdeen University about the current structure and history of the European Union, and various encounters with officials and MEPs began to make me realise that Schumann's concerns had been about supranational egotism.
Yes.
Really were being and had been realised, and that there really wasn't this reflects a flaw in Maritain's reasoning, that
yes.
what they call the fallacy of affirming the consequent. He seemed to think that because the democracy in the Christian sense of the word, as Schumann calls it, is implied by supernatural revealed truths of Christianity. That doesn't mean that those institutions themselves imply those supernatural revealed truths. It doesn't work both ways. The fallacy is if A then B, B therefore A. It's simply not true.
Yeah.
All apples are green. This is an apple, therefore it's green would be true, but this is green, therefore it's an apple.
Yeah, that's right.
Would not be true. And so he. So yes, instead of and I think again, as I've said before, Schumann understood this flaw. So he understood that the benign nature of the structures he created relied on a vibrant Christian culture, and it could assist such a culture, but only if that culture did a lot of work itself. And when that began to be fundamentally shaken, soon after Schumann himself died, then these structures began to drift towards the kind of supranational egotism that Schumann was worried about.
And I read an article you wrote for a paper mentioning Augustine. Could you just bring that little bit of thought on there, because it was very interesting.
So Augustine has quite a shocking analysis of the nature of the state. He takes Cicero's definition of a people from I think it's from De Republica, which is a multitude united in association by a community of interest and a common sense of right. And that word right is jus,
justice.
And from which justitia, justice, is derived. And justitia is to render unto each one that which is his due. And Augustine says, well, the first one to whom something is due is the creator of all things, who's the source of all other blessings and all other obligations. And therefore there can't be a true people, and therefore there can't be a true res publica, unless God is worshipped in the manner in which he is appointed. And if that doesn't happen, then instead what you have is what he calls a latrocinium, a brigandage, a community of brigands united in association by a common agreement on the object of their brigandage and the division of the loot. And so for Augustine, that's it. The world is divided into Christ's church, which is the only true res publica. He says there is no justice save in that republic whose founder and ruler is Christ, and the brigandages, which are the pagan polities. He quotes an anecdote about Alexander the Great, who captured a pirate, and he said the pirate replied correctly when Alexander said to him, "What do you mean by infesting the seas?" And he replied, "The same as you mean by infesting the earth." So for Augustine, a temporal polity derives its legitimacy, a particular potential temporal polity derives legitimacy through its insertion into the order of true worship, which is universal and supranational, the city of God or Christ's church. And he he thought that all other polities were inspired by that desire to grasp that St. Paul talks about in Philippians. Though he was in the form of God,
Did not grasp,
Jesus did not think the quality of God's a thing to be grasped, which is obviously in some ways an allusion both to Adam and Eve taking the fruit and to Satan saying, "I will make myself like the Most High," and he's saying that by refusing to worship God in the manner he has appointed, one is claiming a kind of equality with God. One is grasping, and that grasping upwards also corresponds to a grasping downwards. That is through the brigandage of trying to make yourself equal with God, you become the brigandage which infests the earth. And this libido dominandi, the lust to dominate, turns the pagan polities into these competing criminal organizations, essentially. So for Augustine, the idea that you could have a religiously neutral supranational society founded only on a desire for enrichment. That's really just an attempt to create Babylon by in vitro fertilization.
Yeah, sounds very nice.
If you enjoyed this episode, then please show your appreciation with a comment and perhaps even subscribing to the channel. If you have questions, drop them below. And if you want to go deeper into the subject, then please check out the Saving Europe book and the other videos on the channel, especially the Book Distillery podcast, where me and my blue-collar scholar friends go deeper into these very subjects with top academic guests from around the world. So until next time, thanks for watching.